case briefs, and so much more. LSData's got what you're looking for.
In 1974, a case raised against Thomas E. Mays brought the meaning of mail fraud under scrutiny before the Supreme Court of the United States. The defining question was, is the use of mail to carry out a fraudulent scheme an integral element in fraud or merely an incidental part? The legal entanglement stemmed from events in 1971. Mays, then living with his roommate Charles L. Meredith in Louisville, Kentucky, reportedly absconded with Meredith's credit card and car, embarking on interstate travels. He passed his roommate's credit card as his own in California, Florida, and Louisiana, checking into motels for food and lodging. In an interesting turn, it was these nitty-gritty pieces of housekeeping that led to Mays's indictment. Each motel dispatched invoices to the issuing bank of the fraudulently used credit card. Meanwhile, Meredith had filed a stolen card report. Mays was indicted for infringing federal mail fraud and the Dyer Act and initially found guilty on both counts. However, the verdict didn't hold in the higher courts. On appeal, the Court of Appeals affirmed the conviction under the Dyer Act but reversed the decision on the mail fraud statute. Eventually, the Supreme Court gave its nod to the Court of Appeals' decision. The court cases threw a spotlight on the finer details of law. Particular attention was paid to the mail fraud statute and how it was interpreted. In a series of intricate rulings, the courts concluded that Mays's actions did not constitute a violation of the mail fraud statute. Consequently, the Truth in Lending Act was amended to explicitly outlaw the fraudulent use of credit cards in transactions that have interstate or international implications, an alteration inspired by the very loophole Mays fell through in this case.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.